Alrighty, so today we're going to continue our chat about resulting trusts by taking a closer look at the Type A resulting trust, or as it's also known as the presumed resulting trust. So we may be familiar with the principle that equity will not aid a volunteer, which captures the notion that where a person receives something for no consideration, equity will not impose an obligation in order to ensure the benefit is received. So when it comes to trust law, the point of this is that equity tends to be suspicious of gifts and will often ask that the recipient of any gift to prove that what they were given was actually supposed to be a gift. If they fail to do this, it will be held in trust for the donor, i.e. the person who gave the gift in the first place. In other words, if the person who receives the gift cannot prove that the thing they have was intended as a gift, they hold that thing on resulting trust for the donor. Therefore, where a person transfers property to a third party without value, the transferee may hold the property on resulting trust for the transferor. In general, where a person transfers money, land, or other property to another person without payment, one might think that without any evidence otherwise, it would be reasonable to presume that the transfer was a gift. But equity actually presumes that there is no gift unless there is evidence. So let's take a quick look at a case as an example. In the case of Folkes and Pascoe from 1875, Mrs. Baker transferred property into the joint names of herself and her daughter-in-law's son by the daughter-in-law's second marriage. There was a close relationship between Mrs. Baker and her daughter-in-law, which was not diminished when the daughter-in-law remarried. In fact, she regarded the children from this second marriage as like being members of her family, i.e. like her grandchildren. So, when Mrs. Baker died, the question arose as to whether the daughter-in-law's son held the property on resulting trust for Mrs. Baker's estate. At first instance, the court held that the property was held on resulting trust, but the Court of Appeal later held that the presumed resulting trust, in other words, the Type A resulting trust for transfer without consideration, had been rebutted on evidence that the transfer to the son was a gift. Basically, circumstances showed that Mrs. Baker intended to make a gift, which was proved by the daughter-in-law's son. Okay? So also in the case of Rena Grandolph from 1935, a woman transferred £800 of war loan stock into the joint names of herself and her granddaughter. The woman then continued to receive the dividends, i.e. the income, of the stock. So when the woman later died, it was held that in the absence of evidence proving a gift, the granddaughter actually held the stock on resulting trust for the woman's estate. Again, the onus is on the recipient, so here the granddaughter, to show that a gift was intended. So the presumption is that there's a resulting trust. Now, one of the key areas where the question of Type A resulting trusts rears its head is in cases involving voluntary transfers of land. So, in Section 60, subsection 3 of the Law of Property Act 1925, we're told the following. In a voluntary conveyance, a resulting trust for the grantor shall not be implied merely by reason that the property is not expressed to be conveyed for the use of or benefit of the grantee. So, if you transfer land without value, i.e. the land is given to someone else for free, and there is no declaration of a gift or a trust, there isn't actually an implied presumption of a resulting trust. Instead, the court will look at the evidence to decide if a gift was intended or not. But despite this, this section of the Law of Property Act was actually overlooked by the Supreme Court in the case of Prest from 2013. So basically, in this case, houses had been conveyed to a company for a nominal sum, like £1, I think, and the Supreme Court held that the company held the houses on resulting trust for the transferor. So in effect, they said that the only question is who held the beneficial interest, and they therefore relied on the presumption rather than Section 60, subsection 3 of the Act. To be honest, the question of whether or not Section 60, subsection 3 does away with the presumption of a resulting trust where land has been transferred without value has been a problematic issue for the courts on a bunch of different occasions, and the Supreme Court here missed a fantastic opportunity to make the stance clear. But we do have some more recent cases that do seem to suggest that the presumption of a resulting trust hasn't actually been abolished in cases of voluntary transfers of land, but it's all pretty confusing. It's a very confusing area of the law right now. Finally, we have this idea of the presumption of advancement. So, where a man transfers property to his wife or his son or daughter without value, there is a presumption that the transfer is a gift and not a resulting trust. So here, the burden of proof is reversed. In other words, it's up to the donor to prove that he did not intend to give the gift. Now, you may have noticed that I said where a man transfers property, and this is because the presumption does not apply to transfers from the wife to the husband or the mother to their children or more distant relations. So it's pretty sexist and archaic, which is why this law is set to be abolished by the Equality Act 2010. But for now, it's actually still a valid law until the government decides to commence the relevant section of this act. So at the moment, it's just kind of sitting there waiting to be abolished. Now, one case where the presumption of advancement was an issue was in the case of Tribe from 1996. Here, Tribe owned some shares in a company which operated from some shops which were leased by Tribe. Fearing that he was personally liable for repairs of the shops, Tribe gave all his shares to his son. This was to place those shares beyond the reach of his creditors. In the end, Tribe was actually able to surrender the lease of the unrepaired shops on good terms and no longer needed to keep his property out of the reach of his creditors. Later, his son then refused to return those shares, relying on the presumption of advancement, and that he shouldn't benefit from his own illegal act, i.e. to defraud the creditors. In the end, the Court of Appeal found that the presumption of advancement had been rebutted and that, as Tribe had carried out no illegal act, his son held the shares on resulting trust for his father. So yeah, that's it for now. Make sure you check out my personal YouTube channel for more videos on studying law effectively and efficiently, and feel free to give me a follow on my socials. See you soon.